Heyo, folks, and welcome to another piece of fustercluck committed by the prosecution in the Young Thug trial. As you might remember, a few days ago, Prosecutor Love was admonished in front of the jury. Rightfully so, because she read in an Alford plea in front of the jurors, which is really, really bad. You are not supposed to do that, and Miss Love knows this. And now Miss Love tries to get even, because apparently she believes that any ruling against her is a personal insult. Let's watch how she tries to whine and bitch her way to get defense attorneys admonished in front of the jury.
Looks like it. All right, Ms. Love, you had two different motions.
I do, Your Honor. And one of them relates to the comments by Mr. Weinstein.
Go, Mr. Weinstein, you did nothing wrong.
Cross-examination of Mr. Wright, specifically the comment was maybe about an hour and 19 minutes and 32 seconds from when we stopped. But specifically, the comment that Mr. Weinstein made, to which the state objected, was, you don't know how the state put those words in your client's mouth. And my objection that the court sustained, obviously, is that it was an improper comment, improper statement put before the.
Here's the thing. If this was so improper, then either the judge herself would have brought this up, or she would have asked immediately for, Judge, can we approach? She would, well, she apparently, she already had motions ready to file. She is this offended.
Jury. And even though the court sustained it, Mr. Weinstein and others' ongoing efforts have been to spin a narrative that the state has forced something on one of the witnesses or more of the witnesses, but those.
Which they have. But sometimes it's not proper to ask these questions in front of the jury. But I believe the narrative that the prosecution themselves, because the discourse between Ms. Love and the witness, Mr. Sledge, and even the witness, Mr. Wright, has been to impeach them no matter what. So in my opinion, it is fair game. But sometimes a lawyer will go a bit over the line. But for Ms. Love, she's just looking for an excuse to get the judge to openly and in front of the jury admonish the defense attorneys.
Those particular words, Your Honor, that you put this, you don't know how the state put those words in your client's mouth. It amounts to Mr. Weinstein making a statement, not asking a question, and him making an assertion that the state, in fact, did something that it did not do, which was put those words in your client's mouth. Everybody's heard the testimony and seen what happened. And in as much as that statement was an improper statement in front of the jury, and it could be construed by the jury as something notwithstanding any court's instruction that they could take as fact, we would ask that the court under 17-875 admonish and rebuke Mr. Weinstein's statements and admonish him to make no further efforts to put such improper statements before the jury. My second motion deals with
Let's
Mr.
take them one at a time, all right? Yes.
There was nothing improper about that question to the witness, Your Honor. I was inquiring about the facts. I'm sorry, I'm losing the word, but the facts that were put forward that the state created. The state doesn't deny that they put those together and gave them to Mr. Wright's client without any input from Mr. Wright. I think it was a proper characterization and it was a question. So the witness could answer that, just as Attorney Love has said. All the evidence is out there. It's all before the jury. The jury can draw what they want from that evidence. So there was nothing improper about that.
All right.
And actually, well, that's all I'll
Okay,
say.
so I think it was a mischaracterization. It was in the form of a question, but I believe it was a mischaracterization because if we had been talking about the final version that Mr. Sledge adopted, that might have been a fair statement to say, you know, they were put in his mouth, but these were not things that he ultimately adopted. So the state wasn't putting those words in his mouth. So I think it was a mischaracterization. Don't think it goes so far. I mean, you objected, I sustained it. It doesn't go so far as to warrant an admonishment before the jury. But let's try to be careful in our characterizations, even when we are asking questions. All right.
Yes, Your Honor.
Okay. What's your second motion?
Mr.
Yeah, fair from the judge. But Ms. Love isn't done.
Adams' question to the same witness that the state objected to, but that the jury heard. Isn't it true? And I'm going to paraphrase that you knew that the state didn't want your client, the state wanted Mr. Williams.
Mhm.
That's been the lie that the narrative that has been promoted from the start. We don't agree with it or adopt it. And
Which is, this for me is Ms. Love lying to the court again. Because if the claim from the state is that Mr. Williams is the leader of the YSL, then why wouldn't they go after him? That's pure logic, in my opinion. But apparently, Ms. Love, no, we have no more interest in him than any other of the defendants, which is bullcrap, in my opinion. But let's continue.
certainly don't agree with the idea that we, do these things without a basis for them. So in as much as Mr. Adams made that assertion in front of the jury, we do believe that that merits an admonishment and rebuke under 17-875, and we would ask that the court give him one.
All right. And that statement was essentially, it followed upon another question that was not as objectionable in this way, but that had been sustained. And Mr. Adams, she pretty much doubled down on it and said something to the effect that the state wasn't interested in getting Sledge, they were interested in getting Williams. And that's inappropriate to have asked that witness. And I don't know why you thought that there was any basis for that being an appropriate question, because it would call for speculation anyway. So what's your response to the state's request that you be admonished with regard to that?
Your Honor, it was not a question it was a question that I believed was an appropriate question, given the context of both this witness's testimony and his client's testimony previously. What we'd heard in the narrative that has been put forth, and quite frankly, I believe the evidence has been that the state has been mostly interested in Mr. Williams as a defendant as opposed to the co-defendants, particularly as regards this witness and Mr. Sledge. What has come out and what's been of importance is this meeting that they had on June the 9th,
Mhm.
where the statement is made that is beneficial to Mr. Williams. The part about him advising
Right.
Mr. Copeland or Mr. Sledge to take Mr.
Take
Copeland
Copeland
to the police.
station.
And that's left out of any questioning of Mr. Sledge. He is asked, or however it comes out. There's no discussion about that. We're not going to ask you about that, whatever portion of it you choose to believe. And so there is this narrative that's out there that they appear to be interested in Mr. Williams, not so much in the co-defendants. And the fact that all of the co-defendants who took pleas were asked made or signed plea agreements where the bulk of the plea agreements, and the jury has heard at least 3 of them previously, the bulk of the plea agreements make specific reference to Mr. Williams. Mr. Williams as the head of YSL. Mr. Williams did this. There is this narrative out there that and everyone has gotten probation. All of the people that the jury has heard from has gotten probation after they were denied bond, and the state took a harsh position that they didn't need to be out on the street. But the minute they entered pleas, they implicated Mr. Williams in some form or fashion in their plea agreements, then they were released. And so that
This is a really interesting part of this trial where everybody, all the co-defendants, all 28 were arrested and were kept in jail without bond. Some didn't get a bond hearing until a year later because they didn't have a defense attorney, but that's a whole other issue. But as soon, the prosecution claimed towards Judge Glanville, these are far too dangerous. They are flight risks, yada, yada, yada. And they were held without bond until they signed a plea agreement. All of a sudden, it was perfectly fine with probation and letting them back on the streets. Yeah, I'm as dumbfounded as you guys, but that is the prosecution in this case. Throw a bunch of people in jail, hope somebody takes a plea deal, make them testify in court, and hope something sticks. That seems to be the entirety of their tactics, including but not limited to gossip, rumors, innuendos, and then throw in a couple of the victims of the alleged crimes and hope for the best. And they are spending, rough estimate, $1 million per month prosecuting these 6 guys alone. Rough estimate. But let's continue with this Ms. Love being easily offended B.
narrative is out there, and I think that was an appropriate question to ask of this witness who has some knowledge of that.
How does this witness have any knowledge of the state's desires about who they most want to get with regard to the 19 or so defendants that are indicted in this case?
Because he is a defense attorney representing one of the co-defendants who assisted in entering into a plea agreement. He is familiar with the discovery. He made a statement in part of his testimony previously that he knew what the case was about. And he started going down the road of talking about Mr. Williams before there was an objection made and the objection was sustained. And so he does have knowledge of that. He knows about the case. He knows that Mr. Williams is alleged in this indictment by the state's narrative to be the head of this YSL organization. And he knows that the plea agreements have been to the benefit of the co-defendants who have pled and to the detriment of Mr. Williams.
And every other defendant still on trial.
Well, but he also knows, I asked him one question about, was he in court when he heard the statement that was made by the prosecutor before the plea, made by the prosecutor. It was Miss Lizzie Rosenwasser at the time, where the statement was made that we're interested in anyone who wants to make a deal, except Mr. Williams. We're willing to make a deal. And so he knows this. We're not doing this in the blind. He's aware of this information.
Sadly, that plea hearing was not streamed. But there has to be a transcript somewhere. It has to be, because I doubt this very good attorney would say anything like this unless he had actual evidence for it. For instance, he was probably in court himself that day, him or Mr. Steele.
To respond.
With that? Yeah.
I don't know of that statement that Mr. Adams is speaking about.
Which also points to why Ms. Love is completely inappropriate in prosecuting this case. She claims she does not know. How can she not know what the previous prosecutor who handled this case said? It is Ms. Love's job to know these things. It is her job. Her and the other 4 prosecutors who are in the prosecution's bench, plus the entirety of the DA's office. So I have no idea. That either she's lying or she's incompetent. That's the two only options. Either she's lying or she's incompetent. There are no other choices for her. And I don't think she's incompetent. I think she's very, very skilled. I also believe she is evil. She doesn't care if she lies or not. I believe she is doing everything to get a conviction. And to the degree, and watch my Shane Kendall coverage, she puts vulnerable people in jail, knowing they have a higher risk of dying there. And Shane Kendall died in jail because of Prosecutor Love. But that's another issue. I have so much coverage about the Fulton County and all their screw-ups. Let's continue to listen to this one.
Except Mr. Williams, if he could point me to something, because I wasn't there when she said it. I wasn't even on the case, but I doubt that she would have said it. But if she did, I can't speak to that. I'd like to see it since he's made that assertion. But the second thing is, as it relates to his assertions regarding the plea agreement, Mr. Sledge, I believe, or either Mr. Wright or Mr. Sledge were cross-examined specifically on whether or not the state asked Mr. Sledge any questions about Defendant Williams. And Mr. Sledge said no. And the idea that we're pushing the narrative when the state itself, as the record will reflect, elicited the testimony about Mr. Williams encouraging Mr. Sledge to take Kenneth Copeland to the police station, belies this argument that the evidence that has been brought out by the plea agreements and by the state's actions somehow or another support this, in my mind, baseless assertion by Mr. Adams in the form of, or in the disguise of a question to Mr. Sledge's attorney. There has been, Mr. Sledge's attorney could have been asked whether the state, whether the state asked more questions about one person than another, but actually he was asked and he testified that the question and answer session was more of a kind of get to know you session, and that when Mr. Sledge began talking about Mr. Williams, the state said, the only thing he said about the state is that the state said, that's not the question I asked you. And when he said something about it appeared to be a hot button issue, he later said, there was nothing that you did that made me say that. I just, based on you not asking him about that, I may jump to that conclusion. So putting in front of the witness, this assertion about the state's intention, because as if it's the state that's on trial and that the state is doing something that is just wrong. Is it your?
You are doing something wrong. You are wasting time. You are wasting resources. You are wasting taxpayers' money. The only thing this trial has been good for is shining a light on the moral corruption of the Fulton County District Attorney's Office.
Impression that the state don't really want your client. He wants Mr. Williams. It wasn't an effort to solicit an answer. It was an effort to put an assertion in front of the jury that was improper and that can't be taken back. And that has been the entire.
Well, they're going to make that argument.
Yeah.
Regardless, I'm sure they did in opening and I'm sure they're going to in closing. But I don't believe, Mr. Adams, that there was any kind of a good faith basis to ask that question and to think.
And here comes the judge. Sadly, even though she occasionally goes against the prosecution, I see more and more of the same behavior that Judge Glanville made himself guilty of. Making the prosecution's argument for them, making rulings based on things the prosecution didn't even bring forward. Remember, a judge is the gatekeeper. You have the prosecution, you have the defense. The prosecution argues, these are the case law, these are the blah, 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 these are this. This is what we bring to you, judge. The defense goes, this is our case law, these are our arguments that we bring to you. And the judge, in my opinion, should look at the arguments and make rulings based on the arguments the parties make. In Fulton County, it seems like the judge takes it upon itself. Oh, I know this law that I know that the prosecution didn't bring, but I make it for them because that helps them, which for me is improper. But apparently not in Fulton County.
That was a
Superior
proper
Court.
question for this witness to be able to answer. But Ms. Love, with regard to what you propose is any kind of curative or admonishment, I mean, I don't know what that would be.
I would ask that the court admonish Mr. Adams in front of the jury that the statement he made regarding the intentions of the state as they relate to Mr. Sledge and Mr. Williams were improper statements by counsel, that in those types of counts.
That, in my opinion, would taking away the jury's function as a fact finder. Now, the judge can say, disregard this, disregard that, but then again, she has asked the jury already to forget about about 7 days of testimony. They have asked the jury to disregard. So
Statements. The jury is to remember they are not evidence, but that Mr. Adams should not have made that statement in front of the jury.
Okay.
And
So they weren't statements. It was a question. It was just an improper question. And 17-875 talks about statements of prejudicial matters not in evidence.
And Your Honor, it's not, there's nowhere in evidence. It was a statement that was dressed up like a question, but he made an assertion in the form of a leading question. Was it your?
it's cross-examination. You're allowed to ask leading questions in cross-examination.
Understanding that the state really didn't want your client, he wanted mine. And the fact that he dressed it up as a question doesn't take, our position is it doesn't take it out of the realm of improper statements put before the jury that fall under 17-875 that merit admonishment at the very least, even if not rebuke. But that Mr. Adams should be admonished about that statement. It was improper and it should not. Similar statements, even in the form of questions or disguised as questions, should not be made about the state's intention, which one, no one else can testify about, and two, it was just wrong to put before the jury, pretending it was a question to this witness.
Your Honor, if I may respond briefly.
Go ahead.
I have this witness on cross-examination,
Yes.
and I'm allowed to ask leading questions. I will defer to the court. If the court felt as though the question was an inappropriate question, there was an objection made, and the court sustained that objection. And I abided by the court sustaining that objection. This does not fall under the ambit of 17-875. This is not tit for tat where because Ms. Love was admonished previously, now she's trying to find every opportunity to get somebody else admonished. That's not what this is. Now, I'll abide by the court's ruling, by the court sustaining the objection. But I've stated on the record what my belief was and what my good faith basis was for asking that question in regards to the narrative being put forth in the beginning of this case. And I'll stand by that.
I'm trying to look back at what happened right before that.
Yeah, what happened right before that? Dun, dun, dun. Dun, dun, dun. Skip ahead a bit.
Did.
Okay.
Sustained was, it was your observation that the state wanted this plea to go through as much as Mr. Sledge did. The state objected about on relevance and speculation as to what state wants. Oh, I actually overruled that one. Never mind.
She overruled that objection. How about that?
Oh, I made it a different kind of ruling, and I said re-ask your question.
Yeah.
Based on your conversation with the state, your knowledge of the case, your communications back and forth with the state, your evaluation of the plea agreement you formed, or you observed that the state was just as interested in getting this plea done as Mr. Sledge, wasn't that true? Objection calls for speculation about the state as to whatever his observation is or belief was. It's not pertinent to any material I sustained. And then you followed that up with, was it your observation that the state wasn't really concerned with Mr. Sledge? I think it was with getting Mr. Sledge, but with getting Mr. Williams, which would also have been asking for, what the state wanted or didn't want, which I had just sustained, but asking in an even more pointed way. So it was inappropriate for you to ask that question. With regard, though, to an admonishment, any instruction I give is just going to highlight it again for the jury. So is that really what you want? Why don't I just admonish Mr. Adams privately not to pull anything like that again, or you will get admonished in front of the jury? Would that suffice for now?
Yes, it does. Thank you.
Okay. Are there other issues we need to raise?
Yeah. Ms. Love got halfway there, but be assured, folks, one of Ms. Love's goals going forward is to get one of the defense attorneys admonished in front of the jury, because she sees every ruling against her as a personal insult. She has this God complex that she cannot do wrong. There is no way she can do wrong, which it makes her, in my personal opinion, completely inappropriate to prosecute this case. Thank you guys for listening in. Hit the like button, subscribe if you haven't, and I will see you in next video or stream. Have a good one. Bye-bye.